Good morning, everyone, and thank you so much for joining us for this post-cabinet media briefing. I am Lisa Lord. We will be addressed this morning by the Attorney General and Minister of Legal Affairs, the Honorable Dale Marshall, as well as the Minister of People Empowerment and Elder Affairs, the Honorable Kirk Humphrey, and the Attorney General will begin.
Good morning, ladies and gentlemen of the media. Good morning, Barbados. I am here not so much in my capacity as Attorney General, but as the Acting Minister of Home Affairs and Minister of Information, given that Minister Abrams is on leave. You will recall that just about 2 weeks ago we recommenced the process of having post-cabinet press briefings to cover the 2-week period in between these sessions. So this morning's briefing really is to cover those important decisions of cabinet that took place since our last 2 cabinet meetings ago. With me is Minister Kirk Humphrey, who will be addressing you on the Child Protection Bill. But before I allow Minister Humphrey to speak, I want to say to Barbados and to members of the media that one of the, I think, more important things that Cabinet has done in the since last we were here, and this happened yesterday at our Cabinet meeting, has been to reconstitute and appoint new members to the Parliamentary Reform Commission. This is something that has been on our agenda for quite some time, and actually at the end of 2020, Cabinet did agree to establish a Parliamentary Reform Commission and to its composition. But of course, since then, and this was in December of 2020, at the very end of the year, since then, of course, Barbados transitioned to from a constitutional monarchy to Republican status. In January of 2022, we had elections. We also had the report of the Thorne Commission, and we've also established the Constitution Reform Commission. So there have been a number of things, all of which will, in one way or another, impact on the Parliament of Barbados. So the Constitution, of course, deals with the composition and the method of appointment of Parliament. We have a Parliament Administration Act passed in 1989 that deals with how Parliament is managed. And then we have the 1963 Parliament Immunities, Privileges and Powers legislation, which deals with those immunities that parliamentarians and that Parliament enjoy. Now, of course, no institution is static, and in much the same way as it is important for us to review our constitution, to review our other national structures, to review the matter of how we are headed as a head of state, it is important for us to revisit the issue of Parliament and how it is to function. Let me make it clear that this Parliamentary Reform Commission is not being established for the purpose of looking into terms and conditions of parliamentarians. That is not what it is about. It may consider those issues, but this is to review what Parliament is, how it functions, whether or not it could be better made up, whether or not we should have an upper house and a lower house, whether or not we should have parliamentarians elected by all of Barbados rather than just constituents. All of these, rather than just constituencies, all of these matters are going to be under the purview of this commission. So this is not a commission to be looking at what salaries parliamentarians are to be paid and what other benefits and so on they're supposed to benefit from. The commission will once more be headed by Sir Richard Cheltenham. Sir Richard, as you know, has a long history of public service. He has been an outstanding parliamentarian and cabinet minister, and he's also a renowned Caribbean lawyer and jurist. Sir Richard has once more consented to be the chairman of this commission. His deputy chairman will be none other than Sir Leroy Trotman, and I believe you would know that Sir Roy is internationally recognized as an expert in labor and a labor advocate. I believe he's the only person to have a statue at the International Labour Organization headquarters. But in addition to that, Sir Roy has also been an elected member of Parliament, and he served for many years as the Labour representative in the Senate. Joining them will be Ambassador Elizabeth Thompson, a former parliamentarian, a current ambassador, a brilliant lawyer, and she has distinguished herself both as a parliamentarian, as a cabinet minister, and also in the international arena, working at the UN. Dr. Richard Ishmael will join also. Dr. Ishmael is very well regarded and is a household name in Barbados in the medical circles. Professor Velma Newton is currently the head of the Canadian-funded Juris Project. Professor Newton served in the Senate as well. She was the law librarian. She is well regarded across the region as an institution when it comes to law and legal structures. Young William Chandler. William Chandler is gaining some prominence as a journalist, or maybe as a columnist, and he's very well qualified and represents a younger view. The Democratic Labour Party has recommended Miss Maxine McLean, former Minister of Foreign Affairs, and a member of the Senate, member of Cabinet. And Bishop Joseph Atherley, former leader of the opposition, has nominated Mr. Corey Beckles. And then finally, the Secretary to the Commission will be Pedro Eastman, the current Clerk of Parliament. Let me say that in our view it is important for us that the full panoply of political thinking, political bodies be represented, and therefore, even though none of these people are here as of right, we felt it was impossible for us to look at parliamentary reform without including a nominee of the Democratic Labour Party, and without including a nominee from a most recent political party in opposition. The work of this body is expected to be concluded within a relatively short period of time. We're hoping that within 6 months they will be able to consider all the issues, have public hearings, and submit a report to Cabinet for consideration. This, though, is not intended to take the place of the work currently being done by the Constitution Reform Commission. You will know that one of the important chapters of our current Constitution deals with Parliament, how it is constituted, things of that sort. And I fully anticipate that the Constitution Reform Commission will be receiving significant submissions from the Barbadian public on exactly those issues. But we think it's an important thing for the Constitution Reform Commission to do. And while we don't intend to replicate the work, we believe that the work of the Parliamentary Reform Commission is much broader than the scope of the Constitution and will complement the work of the Constitution Reform Commission. Certainly, Cabinet looks forward to the product of this important commission, but as a Member of Parliament, I think I speak for all of us when I say that we too look forward to an unvarnished view of how Parliament is constituted and to receiving recommendations as to how we should go forward to serve another generation of Barbadians and another generation of parliamentarians. Those are my comments then on this particular element of Cabinet business. I'll now invite my friend and colleague Kirk to address you on the Child Protection Bill.
Good morning to all. Thank you very much, AG. A very special thanks to all of those who have made it here and to all of those who are listening. I also want to thank the number of persons who participated in making this bill a reality. It has been a long time coming. I must tell you that I have had the pleasure of working in social care, social transformation, people empowerment. These concerns have been on the table for a long time. And it is good to be the minister at this point responsible for child protection, to be able to deliver on a promise that we made to the people of Barbados for so many years. Let me also thank the number of persons who would have gone before me. Of course, all the immediate past minister, Cynthia Ford, for the work that she would have done to make this a reality, a lot of the groundwork, the ground preparation. But I also feel we have to go back to Hamilton Lashley and Trevor Prescott and Minister Lowe and Minister Blackett and Minister Sinclair, who at some point in their consideration also looked into child protection. But of course, the last 4 years under Minister Ford and now under myself, we were able to deliver on this. So this protection issue has transcended politics and political parties and governments, and therefore is the most important bill for the people of Barbados. Again, I also want to thank the number of persons who helped. I must thank Faith Marshall Harris, who was part of the committee to bring us here, Jacqueline Seeley Burke, and Heather Stewart from UNICEF, as well as the entire staff of the ministry, and particularly the staff of the Child Care Board, who would have done significant work to be in a position to report today what we are about to report to the people of Barbados. And, you know, this child protection issue is one that requires some conversation. The truth is our legislation is extremely old and would have reflected a Victorian era where, you know, children were to be seen and not heard. In many cases, children were not even to be seen at all. And this legislation, the ones that guide most of our issues pertaining to children, first of all, they're disparate. There's like a patchwork of legislation, and most of it extremely old. And the two that are very relevant to child protection are extremely old. And I'm talking about the Prevention of Cruelty to Children Act, which is 1904. And so, therefore, you could appreciate that being over 100 years, it has its issues, even though there have been some amendments over time. And the Young Person Protection Act, which is 1918, again with some amendments. And the Child Care Board Act being 1983, but very limited in its scope as well. And other pieces of legislation, but they're all over the place. And therefore, the first thing that this legislation corrects is that, you know, you no longer have that patchwork of legislation, but that you have one piece of legislation that is committed to delivering on behalf of children in Barbados. I also want to say at the outset that we had extensive consultation on this bill, because any bill that should make its way to Parliament should be in receipt of extensive consultation. And we had extensive consultation on this bill. The AG would also tell you that we agreed that we should go to select committee and have further consultation on this bill, because this is too important to be the views of a select group of people, even though we believe we've had extremely wide consultation. So when this is introduced in Parliament properly, it goes to select committee, then it comes back for further debate. And I think that is important for us to be able to understand. And so the current set of legislation have their deficits. Naturally, if you have a patchwork of legislation, that in itself is a deficit. And therefore, you have to go to this place or that place to try to address issues pertaining to children. You're probably never sure which piece of legislation is the adequate one to use. In this case, we have everything in one piece of legislation. Another issue that we address in this bill is the lack of legal representation for children. You know, it is found now in contemporary thinking on children that they need to have a say in their affairs, and this bill allows children to be able to have legal representation in the cases where they don't think the Child Protection Authority is offering them the kind of representation that they would like. It's also important to note that our legislation, the current one, has very narrow grounds for intervention. Very, very narrow. In the case of the Child Care Board Act, it means that you have to bring the child into wardship in order for the Child Care Board to be able to act properly. In the case of the Child Protection Bill, it has to be a criminal offense by the parent. We know how, or the guardian, and we now have a range of orders that allows intervention that serve to protect the child. I think the overarching principle in this bill is that everything must be in the best interest of the child. That is clear. That is the principle of this bill. It is obviously the principle of on the Convention of the Rights of the Child as well. We also discussed in this legislation mandatory reporting in this bill, and many persons have asked me what do we mean by mandatory reporting. And in the legislation, and I'm sure in the question and answer we could bring it out, but in the legislation we have deemed certain people as duty bearers, persons who in their professional capacity come into contact with information pertaining to children, like doctors or lawyers or persons you may take your cell phone to who may see something on the phone that is clearly evidence of child abuse. Persons who in their professional capacity come into contact with the information that says a child is being abused, then that person is duty bound to report that child abuse as well. And so that makes it very clear in relation to who has to report, and that's listed in Section 24 of the bill. The bill also addresses the nexus, I think, between child justice and the Child Protection Bill. Now, under the Child Justice Bill, what used to be the criminal offense of wandering and other refractory approaches is now abolished. And the Child Justice Bill, when Minister Abrams brings it, makes it very, very clear. But our two bills work very closely together, so that a child who was once accused of wandering will no longer have a criminal offense. And there is a study done by UNICEF in 2018, and it noted that 60% of both the males and the females in our government industrial schools were there because of these kind of refractory wandering kind of issues. So in our new bill, this is addressed, so that if a child has not committed a criminal offense, it is no longer come into contact with that level of the justice system. It comes into contact with the child care, well, the Child Protection Authority, now properly called. And I think this is very important. If you look at our definition of child abuse, it covers a range of issues that would once be considered the kind of issues that would put a child in contact with the child justice system. This is to protect children at all levels of the system. I also want to say that for children under 12, currently, if a child commits an offense that would be a criminal offense because a child under 12 is not criminally culpable, in the new child protection legislation, that child comes into contact with our secure treatment center. Instead of being deemed a criminal, well, it's difficult to deem a child under 12, but at least they get the care, they get the attention that they need, so that they come into contact with our child treatment center. The other thing is that children between 12 and 18 who are in need of some level of care and protection, and you know this because many children who exhibit deviant behavior, not all, I want to make it very clear, not all, but many, who exhibit this kind of deviant behavior may be in need of care and protection. We've been working very closely with the Ministry of Education to be able to determine how can we help some of those children in schools, and how can we help persons who are already in care. For example, we have children who are in child care board now whose behavior require a level of intervention that is beyond the current capacity of what the child care board can do. And so in our legislation we contemplate, and we're working to build or to create a secure treatment facility where children who need that extra level of attention can get it. And that is going to be critical in the delivery of care, because it means that the children who need care and protection, like love and attention, they get it through the regular facilities of the child care board. The children who, despite our efforts to not criminalize an offense, those children who would then come into contact with the child justice system, but then there are some in the middle who really should never have been in contact with the justice system in the first place, would then be treated under the child care board and the Child Protection Authority. And it is also important to note that in this instance, you need a court order to be able to place a child in this facility. So, you know, every effort between my Child Protection Bill and the Child Justice Bill being brought by Minister Abrams, at every effort, we are making sure that we do the most to prevent children from being institutionalized. And even within the context of an ongoing case, if a magistrate or a judge determines that this child could probably benefit, given the knowledge that he has been given, could probably benefit from being moved away from the child justice system and into child protection, this can also be done. So that level of diversion now exists, again, to prevent children from coming into contact with the child justice system. And the reasons for that are obvious. Of course, when a child comes into contact with the child justice system, the level of stigma that stays with that child often stays for life. The scarring on the child often stays for life. And it's also a duty, I think, on the state to make sure that we offer the correct method of intervention if it is that we choose to intervene. And then there are a number of protection orders in our new legislation which gives a much wider scope to a person who is intervening on behalf of a child. And the current legislation is very, very narrow. This is a much wider scope, and they're all listed between 31, 32, 33, maybe to about 50 in the Act. But there's only one that I would speak on right now, which is the Emergency Protection Order. In a case where a child is clearly in immediate danger, where a child's life is at risk, where a child could be exposed to some undue, unnecessary, and in my opinion, unforgivable harm, then this law would allow for the Child Protection Authority to remove that child without a court order, but the officer would have to apply for a court order within 24 hours. But it can remove the child without a court order. This is to safeguard, again, the interests of the child. And currently that is not in the legislation. So this is a very important step for us. And again, in keeping with our fundamental principle, which is the best interests of the child. And then there are a number of penalties in this act. I will go through a few. And of course, I'm ending on penalties and not beginning on penalties, because I normally find the reverse is true when it is spoken back to me. But penalties are what happens if you don't do what you are supposed to do. And so the legislation makes it clear what you are supposed to do. And of course, none of us would want to have to come to a situation where these penalties and time on summary conviction may be necessary, but they're here, again, for the protection of children. Because my opinion is, at the end of the day, where a child is abused or exposed to harm, somebody has to pay, and it should not be the child. And therefore, that is why this legislation is as strong as this legislation is. So some of the penalties in the legislation, for those persons who are duty bearers and therefore bound to do mandatory reporting, if they fail to report child abuse, they're guilty of an offense and liable on summary conviction. So all liable on summary conviction. I won't say it every time, but liable on summary conviction. And that is $20,000 or 2 years in prison. For a person who makes a deliberate false report, that is $10,000 or 1 year in prison, but it has to be deliberate. If a person acts in good faith and gives you information, but it turns out that the information is incorrect, then there's no penalty under the act. But as if it is a deliberate act where somebody calls and says so-and-so, for whatever reason, is abusing a child, and it's a deliberate act. For a person who obstructs the director in the execution of their duty, in his or her duty, by director we mean obviously the director and all of her staff. A person who interrupts the director or obstructs the director, that's $10,000 or imprisonment for 1 year. I spent a lot of time at the Child Care Board as a manager, and a lot of time in this ministry, but I know of cases where child care officers would go on facilities and people would release dogs or make very threatening comments to the staff. And so we're protecting the children, but we also have to protect the persons whose duty is to protect the children. And that is why these penalties are here. For persons in the instance of foster care, there is a fine. Of course, if you're responsible for a child, you have certain responsibilities, including making sure the child can eat, not allowing the child to run away, and certainly not causing harm on the child. And it speaks as well of if you induce a child or you lure a child to do something, to run away and so on, it is $25,000 or 5 years in prison. And that these penalties are what they are because this government is serious about child protection. In a case where a care center, and the law speaks to care centers, which are persons who are responsible for the care of children, the facilities that you may see, including those that would be under the Child Protection Agency, that they have a right to notify, they have a responsibility, to notify if a child goes missing, and you have to notify. If you do not notify, it is not if the child goes missing, because children do sometimes some things, but if you do not notify that the child has gone missing, or if you are the person who has caused the child to go missing, immediately that's a $25,000 or 5 years in prison. The Child Care Board has always, this is not new, but it is repeated in this legislation, but corporal punishment is not allowed in any Child Care Board facilities. It will not be permitted under the Child Protection Act. And if a person engages in corporal punishment, that is $10,000 or 2 years. Again, everything on liable on summary conviction. Because, the Child Care Board held this view long before I was at Child Care Board, and it is now still currently the view of the state. Perhaps a larger conversation needs to be had on corporal punishment, but that's another conversation for another time. For a person who might seek to personate an officer, that is $10,000 or 2 years in prison. For people who pretend that they work at the Child Protection Agency and they're faking moves, that is $10,000 or 2 years in prison. And the last penalty, and one that I think is extremely fair in these circumstances, anyone who engages in cruelty to children, so the things for which we've listed as abuse, that is $100,000 or 10 years in prison. And so the point that we are making through these penalties is that we are taking this matter extremely seriously. This is, I believe, as the Prime Minister says, as the AG says, this is the reason that we came into office, which is to protect the nation's children. I believe that the legislation reflects the intention of the government to be a responsible government as it relates to children. And this will be the first of a series of social legislation to come. The Child Justice Bill will also be before the Cabinet very soon. Minister Abrams has informed me that it is almost complete. I know that the AG's office has finished their work on it. The elder care legislation, we have finished the policy. Actually, at present, there's over at LASC, there's a consultation going on now. We've asked the Law Reform Commission to help us draft that legislation. We anticipate that will be before us very soon. The draft of the legislation for persons with disabilities is also complete, and that also will be before the Cabinet very soon. So these three major pieces of legislation that have been outstanding for over 20 years since I was at Child Care Board, but in my opinion, outstanding for way longer than that, will now be before the country and before the Parliament before the end of the year. So this is what the legislation speaks to. I believe it is serious enough for our persons to recognize that we are serious about this kind of work. It puts us in line with the issues under the Conventions of the Rights of the Child. But why we are doing it is because it is the right thing to do, and because this government is serious about the work that has been called upon to do. So thank you very much.
Thank you very much, Minister Humphrey. I believe we can open for questions, AG.
Yeah.
Yes, very brief questions, as the AG does have another engagement. We have with us our media colleagues from The Nation, Antoinette Connell and Jamar Knight. We have Shamar Blunt from Barbados Today and Crystal Hoyt from CBC. I believe Antoinette has a question.
Yes, it's for Minister Kirk Humphrey. In the past, we had legislation, but what will cause people to actually adhere to these new laws? And I want to find out what is the procedure for if a child is being abused and you report it, that you won't be shifted from the Child Care Board to the police to some other state agency.
You see, a lot of the problems with current laws for child care, well, there are a few, but the one that I know of most intimately, given that we also just met with the police, is that there are often cases where the time that it may take for a report to reach the police, and I don't mean to be unfair to the police because this is the reality, the time that it may take for the report to go to the police, and people blame the police. They often don't get the report on time. Also, the instances where the Child Care Board, for example, in this legislation, when we met with the police, we had a very open and honest conversation where there's going to be need for training. There's no way we can bring this piece of legislation and not engage in training. So we're going to work very closely with the police to be able to do that. The Commissioner of Police has already given us the assurance that he will make his officers available for the training. In fact, the police have been extremely supportive in all of this legislation. The legislation also speaks to the fact that in cases where we expect, generally, for the police to accompany child care officers, generally, once they know. But the legislation makes it clear that where it's an emergency removal, that we will go so with the police. I think a lot of this is communication. And we had a meeting yesterday in the wider government where we talked about the silos in governments and, you know, not telling others when they're doing things, and this idea that your fiefdom is your board or your ministry. That has to end. And therefore, I believe the nature of the conversations that we've had will allow us to break down some of those silos. We've also been working very closely with the Ministry of Education, because a number of cases of abuse are actually reported through the Ministry of Education. And in cases where the Ministry of Education, through no fault of their own, weren't aware of the procedures, then, you know, again, we're also going to be engaging in training. We've been working on this bill very, very, very closely with the authorities. So a lot of the problems that you see are implementation deficits. And I think we'll be able to correct most of those deficits with training and with communication.
If I can just add, thank you, Minister, if I can just add very briefly. And I think the public has a constant perception that as long as you pass a law, that we expect, or we're entitled to expect, immediate compliance. Human nature doesn't work that way. But what will be important for us as a government to do is to make sure, first of all, that the content of this legislation is very widely disseminated, so that people begin to understand if they are an individual with a duty
Yep.
to report, and for people to understand that we're taking a new approach. Now, under our old systems, you tended to have, this is the law, if you break it, there are criminal consequences. Perhaps the big difference here is that across every element of this legislation, powers have been given, or powers are being given to the director of this new authority to actually intervene in a timely manner and in a way that those powers didn't exist before. So, Antoinette, what I'm really trying to say to you is, whether people adhere to the law or not, what is very different about this new regime and about what we had before is the powers of the state to take immediate action and intervene for the welfare and well-being of the child. And we did not have those powers before. So, yes, we want people to adhere. We always do. But in the event that they don't, we can make timely interventions. And I think that's what will really work in favor of the interests of the children in this instance.
Antoinette, did you have a follow-up? No? Any further questions? Nice and short this morning then. AG and Minister Humphrey, closing comments?
No, I don't think see you next time.
Minister Humphrey?
No, thank you very much. I look forward for us bringing the legislation and working with the media to get out the important parts of this legislation to the people. Thank you very much.
Well, you did ask. This bill has now been laid in Parliament.
Yes,
It was laid on Tuesday. Now, the moment a bill is laid in Parliament, it becomes available on Parliament's website.
Yes.
Okay? So, I, on behalf of the Minister, I'd like to urge Barbadians to go to Parliament's website, find the bill, familiarize themselves with what the bill says. It is important enough to us as an administration that we're going to be taking it to select committee. And when it goes to select committee, the public can come, make presentations. They can say, I don't like this about the bill, or I like this. Maybe we could strengthen this. Have you considered that? Through that process, we can actually refine the legislation and make it even better than it currently is. So please don't wait around until we get to the select committee stage. Go to Parliament's website, download the information, download the bill itself, and start looking at it with a view to both helping us to refine it where necessary, but also to familiarize yourself with it so that you understand what the new environment for child protection is going to be.
Let me just add very quickly on that, AG. On the Parliament's website, the facility exists for persons to make comments on the bill. So if you read it and you want to make a comment, you can comment on the bill. We'd have access to that information. So we're making every effort to make sure that persons have input into the bill. Thanks, Lisa.
Thank you very much. We heard this morning from the Attorney General and Minister of Legal Affairs, the Honorable Dale Marshall, who on this occasion is acting as the Minister of Home Affairs and Information, as well as the Minister of People Empowerment and Elder Affairs, the Honorable Kirk Humphrey. Members of the media, thank you, and you at home for joining. Do have yourself a wonderful Friday afternoon.